and welcome to Canadian Lawyer TV. I'm Leslie Nafusi, and in this episode, we're going to catch up with the Vancouver International Arbitration Centre, also known as VanIAC, who was recently recognized as a top 10 arbitration centre by Canadian Lawyer. With us to talk about their success and the increasing importance of arbitration is Barry Penner, QC and Managing Director at VanIAC. Barry, welcome and congratulations. Could you kindly tell us more about the Vancouver Arbitration Centre?
Yes, thank you. Great to be here and a pleasure speaking to you about the Vancouver International Arbitration Centre. It was initially established as the British Columbia International Commercial Arbitration Centre in 1986 as a joint effort between the British Columbia provincial government and the Canadian federal government. The two attorneys general for the federal government and the province got together and pushed this idea. And so we were launched in 1986 to coincide with Expo 86 that was hosted in Vancouver that year. Part of a government plan to put Vancouver on the map internationally as a financial center. And there were a number of other measures taken and organizations established, but one of them was the Arbitration Center. Just last year, we rebranded and renamed ourselves as the Vancouver International Arbitration Center. So it's a somewhat more streamlined name. And that was based in part on our recognition that internationally, Vancouver is better known than the province of British Columbia, actually. When traveling abroad, I would find people would think that British Columbia might be a country somewhere in Central America, rather than one of Canada's 10 provinces. So we're now the Vancouver International Arbitration Center. And although we were the brainchild effectively of two governments in Canada, we are completely separate and independent of government. We work closely with the provincial government, but we are not funded or controlled by the provincial government in British Columbia. We have an independent board of directors that's made up of a wide cross-section of leading experts in the area and academics and retired judges. And we maintain our independence from the government, but do work closely with them.
Thanks, Barry. And being recognized as a top 10 arbitration center by Canadian Lawyer, what does this mean to you?
Well, we're very honored to have received this recognition from Canadian Lawyer magazine. It represents the collective efforts of our board of directors, which, as I mentioned, is made up of a wide cross-section of people in British Columbia, including our former Lieutenant Governor, Stephen Point, who is a lawyer himself and an Aboriginal leader in our province. And of course, our roster. We have a roster of arbitrators that are experienced and have been qualified to serve on our roster of potential arbitrators. That is broad, approximately 130 people. And so this award really just recognizes their contribution and their efforts, because it really takes a team effort to achieve what we've managed to do over the last number of years.
Excellent, thank you. What specific dispute resolution tools do you offer at the Vancouver International Arbitration Centre?
We can offer everything from mediation to a combination of mediation arbitration, or MEDAR, as well as traditional arbitration. Overall, the mainstay is arbitration. That is the majority of the cases that we handle. And I can say that although 2020 brought lots of uncertainty with the pandemic and COVID-19, in fact, it was a record-setting year for us. Perhaps in part because of the pandemic, people were looking for alternatives as the court system essentially shut down, and we remained fully functional. We made some adjustments. We went to remote hearings. Our staff were able to set up and work remotely, but we were able to basically operate without skipping a beat, and we had our most successful year ever last year.
Barry, what are some of the advantages of arbitration and mediation over traditional litigation?
Well, as I just mentioned, of course, last year we saw the court system, especially in British Columbia, but I know elsewhere in Canada, really grind to a halt for civil matters. They simply had to be put on the back burner as the courts tried to adjust to having hearings without people showing up in person. So people, in some cases, have very few alternatives. But even without the COVID pandemic conundrum confronting the courts, we know that the Canadian court system is fairly notorious for being slow, whereas arbitration can proceed fairly quickly, and you can get your matter resolved on an expeditious time frame with a fair degree of certainty about when it will be concluded. So whereas matters in our superior courts in Canada might take up to 2 or 3 years to work your way through the system, sometimes longer. You can get a judgment or what's known as an award in an arbitration process in less than a year, in a number of months, if everybody's following the timelines and submitting the paperwork in a timely fashion. So one of the key advantages is speed, and then the other, of course, is confidentiality. Whereas the court system is public, and perhaps your competitors in business can go search the registry and see what you're up to. Matters dealt with in arbitration are typically kept confidential between the parties. So that's another key strategic advantage. And then because it's faster, frequently parties will find that their overall expenses are less. We can't promise that in every situation, but typically the procedure is faster. And as we all know, time is money.
What should parties keep in mind if they want to use the arbitration process?
Well, I think the key thing really is to think about it before you have a dispute. Can't always do that, but I strongly recommend that parties, when they're drafting their agreements, when they're talking about who's going to sell what to who and for how much and when, that you also think about that unfortunate possibility, which does happen all too often, where a disagreement arises. And that means you need to have a dispute clause that references arbitration. Otherwise, you'll likely end up in court if there is a dispute, rather than staying out of court, keeping your matter confidential and having it happen on a quicker time frame. So we recommend an arbitration clause, and we have standard wording that you can select from or point your solicitors to on our website. If you go to VanIAC.org, that's VanIAC.org, you can find some suggested wording to add to your agreement about how to handle any potential disputes, including starting with negotiations, possibly having mediation if that's what you'd like, before going up to a binding arbitration outcome. I would recommend you take a look at that wording, talk to your own lawyer or solicitor, get advice on it, but see how you could adapt that to your circumstances. Because once you have a dispute, the other side is unlikely to be quite as cooperative to agree to wording or provisions to get you into an arbitration scenario. They may resist. So better to have those conversations at the outset before there's any dispute about how you will resolve matters in case you do have a disagreement as the contract is unfolding.
Thanks, Barry. I understand when entering into arbitration, an arbitral tribunal is appointed. Can you please share just how they are appointed?
Often the parties will have a clause in their, like I said, in their contract that spells out what happens if there's a dispute. And you can insert right at the outset in your agreement how many arbitrators there would be. For example, it's quite common now just to have one, but traditionally you'd often say there'd be up to 3 arbitrators. So it's really up to the parties to decide that amongst themselves at the outset. Failing that, if you simply say you're going to have an arbitration clause, different provinces have domestic arbitration acts or legislation that will determine how things unfold. And but we really would recommend to the parties that they think about that again when you're writing your contract, whether you want a single arbitrator or 3. 3 is, of course, more expensive because you're going to have to pay for 3 arbitrators. But some parties still prefer that just to have, I guess, greater scrutiny, less chance of an outlier. But increasingly, the trend is towards a single arbitrator.
Excellent. Can you also tell us more about the emergency interim measure?
Right. So this is an important feature that's a fairly new addition to our rules. I mentioned that we rebranded and updated our name last year. We also introduced a new set of domestic arbitration rules. So those are for cases that are not international in nature, but are within Canada. So we've updated our rules and we've added these provisions for emergency interim measures. Think of them like going to court and chambers for an interim injunction. So this happens in cases where you're worried the other party might sell something that they're not supposed to, or dispose of some assets, maybe transfer funds, maybe hide funds, and you're trying to just preserve the status quo. Instead of having to go to court to do that, if you have, again, an arbitration clause in your contract, you could utilize our emergency interim measures to accomplish the same task without having to go to court and have it possibly become public and appear in the media or be scrutinized by your competitors.
What happens after an arbitral tribunal is appointed, and how are the hearings conducted?
You know, traditionally they would happen in a hearing room quite similar to a courtroom, but of course, in a private setting, boardrooms, for example, at VanIAC in our office in downtown Vancouver, we do have boardroom space available. If parties want to utilize space there, we can provide that. Alternatively, there are businesses or arbitration chambers that can also rent out space if the parties want to make their own arrangements, or boardrooms, sometimes even in hotels or conference rooms are available. But with the advent of COVID-19 last year, we saw almost immediately a switch to almost entirely remote hearings being done via technology similar to what you and I are talking on right now, Zoom or Microsoft Teams or something similar. And we provided support to our arbitrators. We offered training and technical assistance to help them make that transition. And overall, it went very smoothly. And I think, I don't want to predict the future, but I suspect doing hearings remotely will continue to be a significant factor. There are some hearings now taking place in person now that vaccinations are more prevalent. And we've had a few of those that we've helped arrange in our office through our boardrooms. But overall, I'd say most of the hearings, the arbitrations, are still occurring remotely via Zoom or Microsoft Teams or something of that nature, like Skype.
And the big question for many, Barry, can you please tell us who pays for the arbitral tribunal fees?
Well, the parties themselves do. And so this is one of the differences between the court system, where, of course, depending on the province, you have to pay some contribution to the cost of the courtroom and the facilities, but it is heavily subsidized by taxpayers. Arbitration is not subsidized. So although we have the support of the provincial government, we work closely with our provincial government, British Columbia, they don't provide us with any funding. We're entirely self-funded. We're a not-for-profit, so we have to try to manage our budget and charge fees to cover our expenses, but we're not profit-oriented, but we do have to have enough income to provide a service. That income comes from the parties that utilize us. So the fees are paid up front to initiate an arbitration, and then depending on what, like for example, if there's emergency interim measures requested, there's extra fees for that. And at the end of the hearing, frequently an arbitrator will assess costs against the party that is not successful. And the party that is successful is entitled to get not just their fees that they paid to the arbitration center for conducting the matter and supervising the matter, but their actual legal fees. Quite different than the court system, where you'll get awarded a tariff, which represents some percentage of your actual legal fees. Frequently in arbitrations, the arbitrator will award your actual legal fees back if you're the successful party. And that's another reason why some people prefer arbitration, because they can actually get their total legal fees reimbursed from a party that is found to have been in the wrong under the contract.
Thanks, Barry. But what if a party is dissatisfied with an arbitrator's decision? Are they able to appeal?
The traditional thought is that arbitration should be a one-time shot and that there would not be any appeals. But then, as you know, the unsuccessful party is often feeling aggrieved and thinks they didn't get a fair shake. So they would then run off to court, even though they agreed not to, and try to get a court to review the arbitration decision. Overall, in Canada, the courts have been fairly deferential to arbitration. They're quite supportive compared to some other countries. But there are times when courts will find a reason to insert themselves and re-examine what it was the arbitrator was thinking about when they made their decision. So to try and head that off, a number of years ago, we amended our rules, our procedural rules, to allow the parties to opt into our own appeal mechanism. So it avoids the courts. You'd have a 3-member panel of arbitrators to review the decision of the prior arbitrator. And that option gives you the opportunity to have a second look, consider it a form of quality control, if you will, without having to run off to the court system and possibly lose confidentiality, not to mention timeliness. So I think that's been an innovative measure that we've taken, that we've added, a neat feature that some parties are interested in. Again, there are some traditional arbitrators or people in the sector that consider that any appeal should not be permitted. But courts are reluctant to be told that they can never review something, right? The courts in Canada like to hold on to the idea that they have some overall jurisdiction to make sure justice is maintained in the country. And so we think that by having this alternative of an internal appeal process for quality control, it actually gives a stronger argument to keep the courts out of arbitration, because there is a relief valve offered through our system of an internal appeal just to maintain quality control in case there is an outlier decision where an arbitrator perhaps was having a bad day when they wrote their original decision.
Great. Thank you, Barry. I understand there's a new procedure for expedited procedures. Can you tell us more about these and what situations they are designed to address?
So this is another change from that showed up in our new rules that we introduced September 1st of 2020. In addition to adding emergency interim measures, which is like going to court for an injunction and a temporary order, we developed a system for expedited procedures where things happen on a faster track at a lower fee. And it's for matters of $250,000 or less. And really the idea here is to make it more economic to bring these matters forward. Increasingly, we have been hearing about businesses that decided, if it was $100,000, $200,000 in dispute, it simply wasn't worth going to court for sure to try and recover that, because your legal fees and time spent just wasn't going to be worth it. Or even in arbitration, it may not be worth it. So we created an expedited procedure for claims under $250,000, where there's a fixed fee essentially for the arbitrator, so that the parties have some certainty about what it will cost. And there's tighter timelines on getting documents submitted and making decisions about who the arbitrator will be and proceeding through the process. And that's actually attracted quite a bit of attention in the last, since we introduced it, September 2020. And I think it's an innovation that will serve us well. We will watch things, how it proceeds. We may have to raise that threshold, but currently that threshold is any claim that's up to $250,000 in value is eligible to proceed through the expedited procedure.
And I understand British Columbia has a new Arbitration Act. Can you please tell us more about that?
So at the same time as we rebranded and changed our name from the British Columbia International Commercial Arbitration Center to the Vancouver International Arbitration Center and updated our rules, on the very same day, the province of British Columbia proclaimed a new Arbitration Act that govern arbitrations that are based in British Columbia. And we worked closely with the government in the drafting of that legislation, provided comments and feedback over a period of about 2 years as the act was in development, and timed our rebranding of our organization and our new domestic rules for the date that legislation would come into force. Under that legislation, it creates a concept of an appointing authority, which means that in the event that parties have said they will arbitrate disputes, if their contract says they'll arbitrate disputes, but they haven't actually spelled out how an arbitrator will get appointed or who that arbitrator will be, and that happens quite often in contracts, unfortunately, then what this new legislation says, if parties can't agree, then the appointing authority will step in with legislative force and make that decision for the parties. Rather than go off to court, it will be this appointing authority. And in the regulations to the new Arbitration Act, that appointing authority is the Vancouver International Arbitration Center. And so we have legislative standing, as it were, recognized by the province of British Columbia to serve this function, to remove one more point of contact with the court system. Again, in an effort to preserve confidentiality between the parties, and also just to try and unclutter matters before the courts. In British Columbia, as elsewhere in Canada, the courts really are under a heavy burden, whether it's family law matters or criminal code matters, and those tend to get the priority. And quite often civil cases, commercial disputes, don't always get assigned to the first available court space. That typically is taken up on criminal matters. So the provincial government here saw some wisdom in trying to just take one more issue away from the courts and hand it to us to relieve some of that pressure.
Barry, thank you again for joining us. And again, congratulations to you and all at the Vancouver International Arbitration Center for being recognized as a top 10 arbitration center by Canadian Lawyer.
Thank you very much. It's a pleasure to be with you and your audience.
You're so welcome. We hope you benefited from this discussion, and thank you for watching Canadian Lawyer TV.